we'll take a quiz on this topic. So let's start. First question is, specific performance may be ordered by court when A. Damages are an inadequate remedy, B. Damages are not an adequate remedy, C. Defaulting party is not ready to pay damages, D. Contract is not voidable. The first was damages is an adequate remedy, second is damages is not an adequate remedy, third is defaulting party is not ready to pay damages, fourth is contract is not voidable. When do you get an order for specific performance? Because normally if you see, the court tries to settle the case by compensation, but where the court feels that compensation is not enough to settle the case, compensation is not a sufficient remedy here, it is not adequate here, then the court orders specific performance. So the answer here should be B. Okay. Next, dash damages are measured on the basis of extent of shock to the sentiments of the promisee. A. Vindictive, B. Nominal, C. Loss of reputation, D. Discomfort. What are the kind of damages which are measured on the basis of shock, hurt, grief, pain which the promisee has felt, which the promisee has undergone? Those are vindictive damages. I told you there are two types. There are two cases where vindictive damages are given. First is the contract of marriage. Second is the dishonoring of check. Now, normally in cases of contract of marriage, the party goes through a lot of grief, pain, discomfort, stress. So, keeping that as a base, the court determines the amount of damages. So those damages are called as vindictive or exemplary or punitive damages. In case of anticipatory breach, where the promisee elects to keep the contract alive, if during the time the contract remains open, some event happens discharging the promiser from his liability, the contract becomes A. voidable, B. illegal, C. contingent, D. void. Now, if you remember, I had told you in case of anticipatory breach, the promisee has two options. Either to consider that contract as breached there and then itself, or to keep it alive. The second option is to keep it alive and go until the due date of performance, and if on due date the contract is not performed, then treat it as breached. So he has two options. Now in this question it is said that the promisee elects for the second option. He keeps the contract alive, and during that period when the contract is alive, something happens which discharges the promiser from his liability. Something happens which discharges the promiser from performing the contract. He anyway would not have performed it, but now something has happened which has discharged his liability for performing the contract. So now the contract will become void. Now no party is liable. Okay. Next, P contracts with Q to deliver possession of a house under construction within a period of 6 months, failing which he would pay the monthly rental of Q. The monthly rental payable to P for Q is in the nature of A. penalty, B. liquidated damages, C. exemplary damages, D. special damages. We have already discussed this point. Look, penalty is something which is exorbitant, which both the parties set under the contract, which is exorbitant. Whereas liquidated damages are the anticipated damages, are the expected losses that the parties would incur in case the contract is breached. Exemplary damages are given to set an example so that other people do not avoid the contracts, they do not break the contracts, and special damages are given only in special circumstances. So here they had already decided that P will give rent to Q if he does not give the possession of the house to Q. Whatever rent that would have accrued to Q, he will give the rent. So that would be liquidated damages. That is the answer. N chartered M's ship and agreed to load it with a cargo in Orissa within 50 days. N was unable to supply the cargo, but M continued to demand it. Meanwhile, war broke out, rendering the performance impossible. In such a case, A. M cannot sue for damages. B. Contract is discharged. C. Neither of them. D. Both of them. Neither of them refers to A and B. Both of them also refers to A and B. Look, N here has already said that he cannot supply the cargo, but M has continued to pursue him to supply. But during this course, you can see that M has kept the contract alive. Though N has come to him, has conveyed to him that he'll not be able to go ahead with the contract, he'll not be able to perform. So this is the anticipatory breach on N's part. Now M has two options, either to consider it as breached there and then itself, or to keep it alive till the due date. Now M opts to keep it alive till the due date, and during that period when the contract was alive, war broke out, and now M cannot N cannot deliver the cargo to him. Any which case he wouldn't have, but now the contract becomes void because war has broke between them. So he'll not be able to send the cargo. So in this case, M cannot sue for damages. B, contract is discharged. Neither of them or both of them. I would say both of them, because now M cannot sue him because the contract is void and hence the contract is discharged. The answer is both of them. In which of the following cases a claim is not enforceable on the ground of quantum merit? A is engaged by B to write a book to be published in installments in a weekly magazine. The magazine is abandoned after a few issues. B is employed as a managing director in a company. After he renders service for some time, it is found that the directors were not qualified to appoint him as such. A undertakes to build a house for B for rupees 25,000. But after having done half of the work, he abandons the contract. B afterwards completes the house. D. A decorates B's flat and fits a wardrobe and a bookcase for a lump sum of 15,000. The work is done, but B complains of faulty workmanship. Now, in which of these cases a claim on the ground of quantum merit is not enforceable? That means three of these cases, in three of these cases, the suit for quantum merit can be done. The concept of quantum merit can be applied, but in one case it cannot be applied. Which is that case? The case is D. Because in this case, the work is indivisible and the contract is also completed. It's not like the contract is half done or it is left in between, or 50% of it or 70 or 30% of it is completed. The contract is completed. However, there is a problem with the quality of the workmanship. Now, if there is a problem with the quality, it will not come under quantum merit, because quantum merit is concerned with quantity. It measures how much work has been done, and according to the proportion of the work done, it gives the remedy, it gives the compensation. In this case, the whole contract is completed, only there is a problem with the quality. So this does not qualify for quantum merit. Okay, that's the answer. Next, G, a film star, agreed to act exclusively for Y, who's a film producer, for 1 year. During the year, she contracted to act for some other producer also. In this case, Y, A, can sue G by an injunction. B, cannot sue G at all. C, has to produce the film with other actors only. D, cannot restrain G by an injunction. Now, G has agreed to act for Y's movie for a year. She cannot act with anyone else, any other producer. However, even though she is under this contract, she is bound by this contract. She contracts with some other producer also to act for his movie. Now, in this case, what is the remedy available with Y? A, he can restrain G by an order of injunction. B, he cannot do anything. He cannot sue at all. See, he has to produce the film with other actors only. Now he has the option of enrolling other actors only. Or D, cannot restrain G by an injunction. Please understand that G is into a contract with Y. So if she is breaking the contract and doing movies with some other producer, G can be stopped by Y. And when you get this order from the court, it is called as an order of injunction. So we can say Y can restrain G by an injunction. Okay. E contracts to marry F. Before the agreed date of marriage, E marries K. Here F is entitled to sue E for A, anticipatory breach in the express manner, B, actual breach in the express manner, C, anticipatory breach in an implied manner, D, actual breach in an implied manner. E is contracting to marry F. Before they were to marry, E marries K. Here F is entitled to sue E for. Now E before the due date marries K. So there is an anticipatory breach. This is the first thing that should come to your notice. Secondly, he did not go to F and said, I'll not marry you. He did not do that. What did he do? He conveyed it in an implied manner by directly marrying K. So we can say that this is an anticipatory breach in an implied manner. So F will sue E for an anticipatory breach in an implied manner. Okay. The damages which are not natural and direct are known as A, penalty, B, liquidated damages, C, ordinary damages, D, remote damages. Damages which are not related, which are not connected, which are not natural and direct to the cause of breach, they are called as remote damages. They are indirectly connected. They are remote damages. And as a matter of fact, you do not have a right to claim remote damages. Only direct and ordinary damages can be claimed. Next, generally, following damages are not recoverable. We've already answered this. Which of the damages are not recoverable? You do not have a right to recover Remote damages, you can recover ordinary damages, you can recover special damages, you can recover nominal damages, but you cannot recover remote damages. Okay. Next. Suman, age of 17 years, enters into a contract for sale of property but breaches the contract before performance. Can the buyer file any claim in this condition? Now, Suman is a minor here. She has breached the contract that he entered for the sale of property. Now, can the buyer, the prospective buyer, sue her? If Suman was a major by age, the buyer could have claimed compensation against her. However, since Suman is a minor, there cannot be any case that would go against her. So our answer should be no. There is no claim in this condition that the buyer can have. Let's check. That's the answer.